Court of Appeal has affirmed the proscription of the indigenous people of Biafra as a terrorist organization.
It was a unanimous decision by the appellate court to affirm an earlier judgment of the Federal High Court in Abuja, which prescribed Ipob. The court held that it found no reason to set aside the order the federal government got against the group. The court also insisted that the federal government acted lawfully by prescribing the organization as its activities threatened the nation's security and continued existence. Recall that in 2017, the former Chief Judge of the Federal High Court, Justice Abdul Kafarati, prescribed the activities of Ipob in Nigeria following an ex parte motion by the former Attorney General of the Federation on behalf of the federal government.
Yes, depending on your time zone and location, from this video in play now. It is now trending all over the social media space. Appeal Court na Abuja Apotago Webia declare finally that Ipob a terrorist organization. The implications of this declaration. And a few days ago, Nnamdi Kanu sued this particular police spokesperson for actually calling out Ipob as a terrorist organization in his speech. So right now, Nnamdi Kanu Legalteam, go the fresh new order Nnamdi Kanu nyeha concerning this declaration. Appeal court may now opt Ipob as a terrorist organization. So ngala hikunu stick here to this update. Alloy Ejimako a drop go a statement from Nnamdi Kanu on his official Twitter handle. Update I can try go down. Alloy Ejimako siwe depth. So stick to this video. Kienoro ife Alloy Ejimako kuru concerning this update and the next step can they take, because they are planning to take this thing international. Or Brazil fag in Nigeria. One day Ezibote fired in a mountain. Ezibote opened on ground. So watch out the video. Kienoro ife Alloy Ejimako did officially na his Twitter handle after they met with Nnamdi Kanu yesterday. So and the updates reads: updates, press statements. The Court of Appeal ruling affirming Ipob proscription. Rising from our routine visitation of Onyen Duma's Nnamdi Kanu today, he instructed the legal team to convey the following members to the public. Now, the ruling yesterday by the Court of Appeal affirming the proscription of Ipob as a terrorist group will live in infamy and thus shall be resisted vigorously within the parameters of the law. Municipal and international, sooner than later, it shall be demonstrated that the judgment did not pass the muster of the Nigerian Constitution and the status pertinent to it. Now, we go further, we see that now members of the public should ponder this. One of the main issues we canvassed at the Court of Appeal was that the order of proscription by the Federal High Court was obtained through an ex parte application by the federal government instead of through a hearing of notice by the judge in chambers. As the pertinent law prescribed, we also argued that the prescription proceedings offended the hallowed doctrine of fair hearing enshrined in Constitution, because Ipob was neither put on notice nor heard before the order of prescription. In addition to this, we argued that the prescription directed issued to the Attorney General was signed by the late Abba Kyari and not by former President Buhari, as the relevant law required. The Court of Appeal acknowledged these laxities, but it still went ahead to dismiss our appeal on the point premise that national security is an exception to the provision of the Constitution. One of them wonders, wherein lies the national security risk posed by the Ipob in 2017 that warranted the flagrant breach of the Constitution, that in its intent and effects discriminatorily targeted the Igbo as a whole. To be sure, the Constitution laid down a process to be strictly followed before any provision of Constitution is suspended for the sake of national security. But in the case, this process was not followed at all. For avoidance of doubt, the Court of Appeal decision will hardly have any prejudicial effect on Nnamdi Kanu's main case, because the decision is not final and we are heading to the Supreme Court, which is by law the final arbiter. There are also other myriad and varied legal options that can be triggered against anybody or entity that might attempt to take undue advantage of the Court of Appeal judgment to wrought legal and constitutional injury on Nnamdi Kanu and Ndi Igbo. So, for the time being, it is legally safer and wiser for all and sundry to resist the dangerous temptation of calling Nnamdi Kanu a terrorist until he is either convicted as one, which is a tall order, or until the Supreme Court finally decides it against him, which is highly unlikely. In plain terms, the jury is still out on the issues of whether the Ipob and Nnamdi Kanu are terrorists or not. Thus, anybody or entity that sees the adverse moment to pervade the label that Nnamdi Kanu and Ipob is a terrorist will be countervailed by epic legal actions that will be prompt, muscular, and scorched earth. Let it be clear that it is only those who are unfamiliar with the pathological and institutional disdain against the Igbo in Nigeria that will be surprised at an infamous court ruling that manifested no regard for the Constitution of Nigeria, elevating denial of fair hearing to a state where it receives judicial blessings is absurd and perverse to boot, and it shall not stand. Signed, Aloy Ejimako, Esquire, F. Nnamdi Kanu, Legalteam, 31st January 2025. So if I need yesterday, if I need any appeal court that we be asking Nnamdi Kanu and Ipob the terrorist organization. So if Ipob a terrorist organization, meaning that Nnamdi Kanu be a terrorist. So una fugo kosi na that they are working very strong to take this matter serious to a higher level. Ebe haga trash the whole thing. Ebe haga etinyanya we labor anya. Yes, because if Ipob a terrorist group, meaning that if bondi bonine as terrorists, because Ipob indigenous people of Biafra. So because they can afford this updates, drop one opinion in the comment section of BK to surround the video. Can do some when we this update. See you guys in my next video.
Celestina, let's begin with the prescription of Ipob. What is the implication of the decision of the Court of Appeal on Ipob's prescription?
Okay, with the judgment today delivered by the Court of Appeal, Ipob remained prescribed as a terrorist organization. We recall that in 2017, by way of an ex parte application, the then former Minister of Justice, Abubakar Malami, approached the Federal High Court here in Abuja, seeking for the order to prescribe Ipob, which the former Chief Judge, Justice Abdul Kafarati, granted, and Ipob was prescribed. But the little confusion that happened was because in 2023, which was 2 years ago, another court at the High Court in Enugu State also gave an order setting aside